Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Very recently, I think yesterday, I have given you a beautiful case law, that is Gayatri Hospital case regarding res sub judice, which is envisaged in section 10 of the CPC. Today, I am going to tell you regarding section 11. So, section 11, please remember, it deals with res judicata. Res judicata, please remember, it is basically universally accepted principle of law. Number one, it applies to both CPC and CRPC. Number two, it is decided on public policy. These 3 points don't forget. Simply to say, once a matter is finally decided, no parties will be permitted to reopen the same. So section 11, simple reading says like this. No court shall try any suit or issue in which the matter is directly and substantially in a formal suit between the same parties and when it has been decided by a competent court. When it has been heard and finally decided. Yesterday I explained you what is heard and finally decided. So there are 3 legal maxims, I can say 4 legal maxims in this res judicata. Number 1, ex captio res judicata. That means one suit and one decision is enough for any single dispute. Please remember, this doctrine came in public interest, larger public interest. What is interest? So, interest republicae ut sit finis litium. That means in the interest of the justice, please remember, in the interest of the state, there should be an end to the litigation. So, very famous case law, Lalchen versus Radhakrishnan, 1977. And another maxim is there, nemo debet lis vexari pro una esteda idem causa. That means no man should be vexed twice for the same cause. Already Article 20, Clause 2 of the Constitution of India says regarding the same in the name of double jeopardy. Right? So, for example, I have written the notes also. Please remember, A files a civil suit against B for damages for breach of contract. But he could not prove it, the suit is dismissed. Once again, A files a suit against B for damages for breach of contract. Here, A files a suit for damages breach of contract, but here once again he files another. The second suit is barred as damages are already decided in the former suit. So, and in this connection, please remember explanation 4, that is constructive res judicata. What is constructive res judicata? Whenever, please remember, either for attack or defense, you take one thing, you should continue the same. So, you cannot take advantage of one particular point at one stage, and in the appeal stage, you cannot deviate from the same. So, please remember, this constructive res judicata is very important. So, please remember, it requires the matter which might and ought to have been made a ground as an attack or defense, then you cannot go away from the same. So, in this connection, I have told the important case, that is State of UP versus Nawab Hussain, 1977. Actually, this Nawab Hussain is a sub-inspector of police. So, he was dismissed by the department. In the first instance, please remember, the person who was dismissed, he approached the Honorable High Court and challenged the said order of dismissal, holding that. So, he filed a writ petition before the court. So, contending that he was not given a reasonable opportunity to defend himself. But the department proved that yes, they have given him opportunity, but he could not avail the same. Therefore, the High Court dismissed his petition. Okay, then. Once again, agreed by this, the SI filed another suit with an additional plea stating that DIG is not a competent person to dismiss him because he was appointed by the IGP. So, as such, the DIG was not competent to pass the orders against him. So, please remember, now here the state of Gujarat, they argued that it comes under the so-called expression 4 of the section 11, that is constructive res judicata. Had he taken the defense of the so-called reasonable opportunity on one side and also together with the so-called appointing authority, yes, it would have been used. But here, in the earlier stage, he has taken the reasonable opportunity. Now he has come with the appointing authority. So both of them clash with each other. So if the court allows, likewise next time he can come up with some point. This is not acted. So this is where the point of constructive res judicata comes. Supreme Court held that the second suit is clearly barred by constructive res judicata as the matter was already finally decided as a writ. So the defense should have been made a ground in the formal proceedings, but it was not made. Therefore, it is a clear case of constructive res judicata. So please remember, study the cases thoroughly. It's not that easy to understand the problems, the issues. It is very rigid, but anyway, you have to write the examination, and I am sure I am going to give you as the seminar topic also. Please read the topic of res judicata and enrich your legal knowledge. You have to cite minimum 2 cases during the seminar. Okay, thank you.